this little life. This little life.
All right, so I just watched a video about someone driving that said that they were almost in an accident and almost injured their passenger. Hi, I'm Blake Zaccagnino. I'm an attorney from Buffalo, New York, and I handle mostly personal injury claims, so car accidents, trip and falls, things like that. And what I like to do on my spare time, I know it is nerdy, but what I like to do is comment on videos that I see on the internet, whether they be fail videos or funny videos that are posted that remind me of legal concepts and then give an explanation of that concept. So here, what this made me think about is how fault is split between drivers in an accident when a car accident happens, and also how a passenger's injury claim is handled as it goes to the fault issue. So generally, when a car accident happens, a judge or a jury will apportion the fault between each driver involved. And generally, the judge or the jury is free to apportion 100% on one side, 100% on the other side, 50% on one side, 50% on the other side. But generally, they will be instructed to apportion the fault 1 to 100% between each person involved. And how it plays out is, or the effect of that is, whatever percentage of fault is placed upon the plaintiff, as long as it's not 100%, and as long as there's some fault placed on the driver that they're suing, a plaintiff's own percentage of the fault will reduce the amount of damages that they actually get. So the blue book value of their injuries will be reduced based on whatever their own percentage of fault is. And what I wanted to do was to read you some case law that somewhat explains the concept. So it says, in essence, the pure comparative negligence model, that is CPLR 1411, allows a plaintiff in tort to recover regardless of the extent to which his or her culpable conduct contributed to the injury at issue. As one commentator put it, in theory, a plaintiff who is 99% responsible for his own injuries may still recover 1% of his damages. Now, what the video also reminded me of is how a passenger's claim is handled from a fault perspective. So in most circumstances, I think we can all agree that a passenger who is not driving is not at fault for an accident. They're the passenger. So assuming that the passenger didn't do anything crazy to cause or contribute to the accident, they were just sitting there normally and then the driver's accident happened, that passenger would have a claim both against the driver of his vehicle in addition to the driver of the other vehicle. So they would have two claims. And where an issue that comes about in those cases is because of the potential claim of that passenger against the driver of the vehicle that they were in addition to the other driver, or the driver of the other vehicle, generally it is advisable for the driver and the passenger of a vehicle to have two separate attorneys, because what that situation does is it presents a conflict of interest. In other words, the attorney that's representing the passenger would also have to possibly bring a claim against the driver. So that presents a conflict, which is why ordinarily and generally in most circumstances, a passenger and the driver within the same vehicle should have two separate attorneys. So those are just a couple things that I had in mind and that I was thinking about after I saw that video. So if there's anything that you want me to clarify or any additional information that you want me to research and do a talk on, let me know and leave it in the comments below. Thank you.